We are on section 6 of remedies. This is the first class in section 6. And this section deals with a few cases with respect to the manner of proceeding with respect to injunctive relief and the like. And also we're going to focus a little bit on Rule 12, motions to dismiss, which become a really important part of practicing civil litigation. A lot of cases you will see a motion to dismiss. Sometimes it's because filing a motion to dismiss provides you additional time to investigate the matter before filing an answer, but oftentimes where you have a multiple count complaint, it's not unusual for a defendant to try and get rid of some of those counts before moving further along with the case, because what at the minimum it does is might narrow some of the discovery that's needed if some of the counts are no longer proceeding through discovery and ultimately either summary judgment or trial. So a lot of times defendants will start out with a motion to dismiss. We're going to look at that. Well, we might as well just look at it right now, because there's a couple of things to think about with respect to motions to dismiss under Rule 12. First of all, as you know, I call it the one of the three testing motions, along with motions for summary judgment and motions for judgment as a matter of law at the time of trial. But motions to dismiss are likely the first motion we see after we've filed a complaint, or the first motion we file if we're representing the defendant. I call it a testing motion because what you're testing is to see whether there are any procedural or substantive deficiencies with the plaintiff's complaint. Oftentimes, if you look at Rule 12, whatever various motions you have with respect to moving to dismiss have to be filed together. So if you're arguing about lack of personal jurisdiction or improper service or any number of different items listed under 12B, the best practice is to join all those various motions at one time, because the failure to join them likely means a waiver of any of the ones you didn't bring. Many of these motions to dismiss under Rule 12 can also be filed as affirmative defenses as part of your answer. So there's two different ways to do it for many of them, but oftentimes the best practice is to file a motion to dismiss, have that resolved before we proceed any further, especially if it's a motion to dismiss that has a good chance of being successful in defeating the entirety of the claim. But what it does is, in filing a motion to dismiss, it tolls the time for filing an answer until the court has resolved that motion to dismiss. So normally your answer is going to be due within 21 days of service. If I file a motion to dismiss instead, I do not have to file that answer and any counterclaims until such time as the court resolves the motion to dismiss. So it can delay the matter and also buy significant amounts of time as the defendant is testing that the complaint's sufficiency, either because it's factually or legally insufficient. Now, a couple of things to think about in motions to dismiss. It's supposed to be judging the complaint with the benefit of the doubt, obviously, to the pleader to see what problems there might be. If there are, if the argument is it's 12B6 motion, failure to state a cause of action upon which relief can be granted under the law, then matters outside the complaint are not supposed to be looked at. You're supposed to look only at the complaint, and to the extent that you considered affidavits or matters outside the complaint, potentially it turns it into one of summary judgment. So theoretically, one could move, and I've seen it done, where people move to dismiss or in the alternative for summary judgment right from the outset. So you want to be cautious of that and think about that as well. But there's many other reasons to move to dismiss: lack of personal jurisdiction, improper venue, insufficiency of service of process, failure to join a party under Rule 19. So there's a whole bunch of different reasons, not just a 12B6 motion, failure to state a claim upon which relief can be granted. Now, there's a couple other parts of Rule 12 that we really never talk about, and I've never talked to you about them, but I just want to reference them since we're looking at each of these rules in a little more detail than we would normally. Go ahead.
Question.
Yep.
Can you just, so when you're filing your 12B6, your motion, do you file, and it deals with just the complaint, do you have to file a summary judgment motion, file that motion?
Down the road, yes, but no.
Well,
Sometimes parties will move for motion to dismiss. The 12B6 is the failure to state a claim upon which relief can be granted. Theoretically, if you work that through, the only thing we should be looking at then is the complaint itself to see if it adequately states a cause of action upon which relief can be granted. To the extent that you look at anything other than the complaint, then potentially it turns it into one of summary judgment, because you're not just testing the complaint anymore, you're looking outside the pleading. And that has the ability to turn it into one, not just as a motion to dismiss, but a motion for summary judgment, to look at the facts and everything that's considered at that point. And that's why sometimes it's just a motion to dismiss for failure to state a cause of action upon which relief can be granted. If it's coupled with an affidavit, then that technically could turn it into one of summary judgment. Some people will say it's a motion to dismiss or in the alternative for summary judgment right from the outset. And then it's clear that they are going to likely provide the court additional information, usually by way of affidavit and the like. And theoretically, not just theoretically, as a practical matter, if the court goes outside the face of the complaint on a motion to dismiss for failure to state a cause of action upon which relief can be granted, it's no longer testing just the face of the complaint. It's looking at other things. That's not strictly a motion to dismiss any longer. Okay? But there are other reasons, personal jurisdiction, subject matter, improper venue, they can look beyond the complaint itself for those grounds. But it's only 12B6, failure to state a cause of action upon which relief can be granted, that you're just supposed to look at the complaint.
So do you file that 12B6 along with like an answer?
No. When you file any of the motions under Rule 12, any of the grounds under Rule 12, you don't have to file an answer at all, because your answer, the time to answer, is told until such time as the court acts on that motion. Because let's assume they dismiss the entirety of the complaint. There is nothing to answer to them.
So what if your adversary starts to point out things that's not in the complaint? Could you move for a summary judgment?
Well, no, you could. Listen, anyone can move for summary judgment at any time. The problem is that just because they're looking at matters outside the complaint doesn't mean that you're going to satisfy the summary judgment standard, which says there's no material facts in dispute that rise to a tribal level. The moving party's entitled to judgment as a matter of law. What you can argue is that they're no longer moving to dismiss because they're asking the court to look outside the face of the complaint, and on a motion to dismiss for failure to state a cause of action upon which relief can be granted, we're only supposed to be looking at the four corners of the complaint. Assuming the plaintiff can prove those allegations, does it adequately state a violation under the law? Okay? But there's a couple other things I want to, and by the way, most complaints start with this. Because, let's assume I have, a typical complaint. I've got maybe 4 or 5 different legal theories, that I'm advancing, even in what might be essentially a breach of contract claim, but I likely have an unfair trade practices. I may also have a quantum merit, right, an equitable claim saying, well, if there is no contract, they still owe me for the reasonable value of the services. I might have some type of tort for misrepresentation or, theft of trade secrets or whatever. But oftentimes, I'm not just pleading one single legal theory, I've got multiple ones. Well, they're not all as strong as each other. As I've said to you when we looked at 93A actions, if I have any legitimate basis to plead a 93A, violations of unfair trade practices. I pleaded. The reason I pleaded is because it provides treble damages plus attorney's fees if I'm successful, if I have to go to trial on that matter and I'm successful. Well, that's huge. That changes the dynamic and the risk for the defendant moving forward. All my attorney's fees from the time I file suit through trial, that's in some of these business disputes, in most business disputes, that's hundreds of thousands of dollars. The threat of doubling or trebling a judgment, and again, say, a business type suit, even if it's for $500,000, that turns a $500,000 claim into $1 million or almost $2 million claim. That's huge. That's a huge difference. So, as a practical matter, we plead these unfair business practices. I do most of my stuff is business litigation, but you plead those theories. Are they all super strong? No. So sometimes what you'll have is a motion to dismiss at the outset to try and whittle it down. This recent case in Connecticut that we had, we pled both violations of the Massachusetts Unfair Business Practice Act and Connecticut Unfair Business Practice Act as well. Now, theoretically, they both can apply. But there's a legitimate question, which one should have? There was a choice of law, but what happens if the choice of law isn't honored? And actually, there were two different contracts with two different choice of law provisions in them, so it was a mess. But so you plead what you have as viable theories, and at some point it's all got to be sorted out, but it doesn't have to be sorted out necessarily at the complaint stage. And so a lot of times the defendant's goal in civil litigation, and I'm not encouraging you to do it, but I understand why it's done, and it is done consistently, is to delay the matter as long as they can. But in the same vein, I'm telling you as the plaintiff's lawyer, my job is to get that case to trial as quickly as possible. But the defendant oftentimes sees their job as to drag it out as long as possible. Now, that's not appropriate if it's done solely for that reason and without any legal basis to do so. But I'm calling a motion to dismiss a testing motion. What the hell you got to lose by testing it? And that'll buy you 3 months easy. So again, it serves two goals. It tests to see maybe I can dump some of the counts, but it also says, well, I'm going to buy myself 3 months in this process and make it a little more expensive for the plaintiff to continue to pursue it. It's not done in violation of Rule 11. I'm not telling you to do that, or should you do that. But also the fact that it meets both goals of testing and making sure that the plaintiff has claims, all of their claims are valid to go forward, but also every day I keep the dollar in my pocket is a victory for me. And so you're oftentimes going to see a motion to dismiss, often. But there's a couple other motions under Rule 12 I want to point out to you because we've never, well, first of all, it talks about, I'm looking at the federal rules now, not Mass or in any other state. You don't have to file an answer then until 14 days after you get notice of whatever the court does on the motion to dismiss. So you bought yourself a lot of time to investigate, to get your facts together, get your pleadings together, get whatever counterclaims you have together to really pull the information together. Go ahead.
Can you repeat that? Like
Yes.
You have 14 days.
If a defendant files a motion to dismiss, not only do they not have to file an answer because the motion to dismiss is there for the court to rule on, but until such time as the court rules on it, and you get notice of that ruling, at that point, the defendant has 14 days from there to file their whatever response and pleadings they're filing, which would likely be a complaint and perhaps a counterclaim.
If the defendant files a motion to dismiss, you have...
They have.
Oh.
Because the plaintiff has filed the complaint. The only person that has anything, the response of pleading to the complaint is the defendant. But they have now bought themselves a lot of time in order, because the court has to rule on that motion before they're required to file any answer or counterclaim.
Okay, and you said which one is the 14 days?
No, so then once I open up my mail someday and it says motion to dismiss denied, At that point, I know as the defendant, I've got 14 days to file any answer and counterclaim to that action.
Okay.
Okay? And if I don't, obviously, then there's additional problems from a standpoint of default and things like that. But obviously, if they file a motion to dismiss, they're almost always going to then proceed with the balance of the defense. I want to make a motion, make a note of Rule 12C, because we never talk about it, but it's called a motion for judgment on the pleadings. It says after the pleadings are closed, so that means after the complaint is filed and the answer. A party can move for judgment on the pleadings. Judgment on the pleadings simply says, like summary judgment, is look at the complaint, look at the answer. They're not disputing what happened here. We believe that the court doesn't have to look at anything else, but they can grant us judgment on the pleadings. Every now and then you see it. It's rare, but it is possible to do under Rule 12C.
So when they say it's treated as a summary judgment motion, does it mean that it has to meet that standard of a summary judgment?
Yes.
Okay.
Yes, exactly, because that's the same thing for C and a motion to dismiss if they had a stated cause of action. If you go outside those pleadings, now it's turning it into one of summary judgment, which means you now use the summary judgment standard, not those standards. Okay? That's what Rule 12D says. And then I want you to look at 12E, and it's a motion for a more definite statement. And I've seen this used as well. Now, to me, okay, let me first explain what it is. It says, listen, I see your answer, but I see your complaint, but I don't really know what it is you're saying, you're accusing me of, and I need more details to be able to file my response. Now, to me, that's BS, because if you really thought that it didn't state a claim, you should be moving to dismiss, right? So either you have enough to plead in response, or what you're really doing with the 12E is you're looking for additional discovery information, but you're looking for it before discovery. And that's oftentimes what the courts will see this as. And so if you can frame a response, then file your answer in whatever counterclaim you want, if that's your goal. And if you can't, then it should be a motion to dismiss. But I've seen, again, people use this. I think, again, it's sort of a delaying tactic. But because what you're saying is that it's so vague or ambiguous that the party cannot reasonably prepare its response. Well, that would seem to indicate that you haven't adequately stated a claim upon which relief can be granted to me, too. So why wouldn't you be moving to dismiss, which you would be better off doing? So to me, this is used to delay the matter, and I think if it's not being used for that purpose, what you're trying to do is gain additional information that you would normally obtain through discovery, but you're trying to get it early before you've framed any response. So in essence, that you can frame how you're going to defend it with the additional information that you're requiring to be filed. So to me, I would be careful using this. And to me, it's rare that the court would actually do it. But I've seen it used, and I mean, I don't represent defendants, but to me, I don't necessarily see the basis for it, because I think you'd be better off with the 12B motion. I'm going to mention 12F. You don't see it often, but I want to mention to you again, just so that you have a little, just so that you know it's there. And 12F is a motion to strike. And what it says is the court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Sometimes, it's rare, but sometimes parties will plead either as part of their complaint or their answer information that isn't really pertinent to the legal claim, but is likely put there to embarrass the other side. And what this allows you to do is to move to strike anything that's redundant or impertinent or scandalous that's really unnecessary to be there, but is there more to cause embarrassment and things like that. And that's, again, you don't see it often, but you would see it, and it depends. Also, if you need to use it, it should tell you something about, who you're working against, because what we're saying here is, if you're going to use it, this is unnecessary material, but the likelihood is they're doing it there to cause embarrassment or because it's scandalous. Well, if it doesn't advance the claim, there's no reason to do it, so why did you put it in? You put it in likely so that you would be able to use it as a wedge potentially to settle or embarrass the other side to settle, or if they were going to take it to trial. So you do see a motion to strike on occasion, but it really has to be what it says: scandalous or impertinent or redundant or immaterial information. You just can't strike it because you don't like it. If it's a defamation claim and he called you a dirty SOB or whatever other vile names, well, that's relevant with respect to the defamation claim. You can't just strike it because it's nasty stuff. There's a lot of nasty stuff in law. The question is it scandalous and unnecessary, or redundant or immaterial and unnecessary?
Question.
Yep.
Have you seen, like in 12E, it says a pleading, right? A responsive pleading.
Yep.
So, okay, we understand that a complaint has to be filed and that can be vague and ambiguous. An answer, I can't see how an answer can be vague and ambiguous.
Sometimes they can be, sometimes it's probably more 12F, I would see, as opposed to 12E. But a lot of again, we'll take this one in Connecticut but he was a classic jerk. They probably had, honest to God, 30 affirmative defenses. They just threw the kitchen sink at it. Now, you could have moved to dismiss some of the affirmative defenses or strike them or get a more definite statement as to, it just was BS as to, and so, again, I'm not going to play that game. My job as a plaintiff, I want to get to trial yesterday. So if I get bogged down and moving to strike and all the rest of it, then I'm biting on the hook that they've fed. So, but yes, you can see a lot of answers that I would actually argue, but again, I'm a plaintiff's lawyer. I would argue I've seen more answers in violation of Rule 11 than complaints, because just like complaints, those answers are supposed to be factually and legally investigated. You're not just supposed to file it for the purposes of harassment or delay. They're supposed to investigate it as well. But I have seen far more answers that simply deny every one of the plaintiff's allegations and then throw in what I call the kitchen sink affirmative defenses, 30 in number. There's no way you have 30. You might, if you're lucky, you might have a couple good affirmative defenses. But what they do is they bury the two good ones with 30 others, and so I've got to really look and carefully pick through and figure out which one are they really looking for here. But what they've tried to do is hide the ball. So I've got 28 of 30 that really are absolutely irrelevant. I could do this, but I'm, and I probably should do it more often, but again, to me, then I'm playing that game. I'm getting bogged down in the details, and I need to get to trial.
So doesn't the judge or the court penalize people for?
They should more often. I don't see it. I'm just telling you my experience. I think it's far easier to slap plaintiffs and their lawyers for filing a complaint because the court doesn't see it as legally sufficient, even though you've got an injured individual damaged as a result of the defendant's actions, than to hold the defendant to the same good faith pleading standard. I'm just telling you my experience is I don't see it treated the same way. And I think we could advance the ball so much further if the defendant had the same obligation. Don't just deny everything, If you know that you fired him on April 1st, 2015, then just admit it, right? I mean, just admit what you can admit. and we can start to streamline some of these cases for trial and figure out what we really need through discovery and what we don't have to get because some of these issues have been conceded as non-issues. But I don't see it, and I don't see the court holding them to that standard, because especially in the realm of, like, I could never be expected to file a 100-count complaint just naming every legal theory you ever learned in law school, and just file it to see what sticks. But that's the way a lot of people plead affirmative defenses. They plead virtually everyone they can think of, even though clearly half of them wouldn't apply at all. And I think if the court actually, or maybe Ray's point now, well, maybe you should be bringing this motion to get rid of some of these so you really can figure out which one's right. But I don't feel like waiting 3 months to get to the next stage either. So, I mean, I hear you, and I don't know whether the court would hold them to that standard because, again, I think plaintiffs are held to a harsher standard than the defendant is. And that's too bad because that's not what either of these rules actually mean. The last part of this I want to mention is, except for your judgment on the pleadings, these motions need to be consolidated. You don't get to bring them serially. So if you think you've got a lack of personal jurisdiction and an improper venue and process was served improperly, those should be joined together. You don't get to bring improper venue and then come back and say, oh, insufficiency of process. As a general matter, you want to plead them all together. And lastly, as I said to you, these can also be, if you look at 12H, you can find, no, it's not 12H. No, yeah, you can look at 12H because it's the second half of it. That when it's 12B 2 to 5, you either need to bring in a consolidated motion or look at HB 2I, included in a responsive pleading or an amendment allowed by Rule 15. So you actually can file it in your answer as some of these as affirmative defenses. And that's kind of a clever way to do it too, to me, and I've seen it later on down the line. Like, let's suppose you do argue lack of personal jurisdiction. But if I bring it up early by way of a motion to dismiss, and the court says you're right, you're out, dismisses the case, then that potentially gives the plaintiff time to go file it within the statute of limitations in another jurisdiction where they can obtain personal jurisdiction. And so that's why sometimes defendants will use it as an affirmative defense. Now it's kind of odd because what that means is they're going to defend the suit otherwise, which is expensive in a lot of these cases. But then when that issue is going to be resolved about whether there's personal jurisdiction or not is closer to trial, because that's where it has to be. It says before trial unless the court defers it even further. But that could be 2 to 3 years. It could be at least 2 years from the time suit is filed. What that might mean on a tort claim is that the statute of limitations has now expired, and if in fact they're right that there is no personal jurisdiction, the case is dismissed 2 years after filing, they may be home free. So sometimes defendants will use that as an affirmative defense. You'll look at it there, and you better, when you see that one, you got to take a hard, or venue too for that matter, you better take a hard look and say, okay, are we really right here? Is this just, sort of what I've described, the kitchen sink defense, or is this legit? Because if that's legit, then I might need to think about trying to fix this. Maybe I might have to dismiss and go to a different forum because I can't take the risk that 2 years down the road they win, statute of limitations has expired, client's asking you why you picked the wrong court. So that's one of those ones that when you see it as an affirmative defense, not a motion to dismiss, just check it. Just check and make sure you're comfortable with it. It could be BS. Usually I would think it would be, simply because the cost to defend these suits could be tens of thousands of dollars. But it's a question of what's at stake at the end. If it's $50,000 to defend the suit, but I'm going to avoid a $2 million judgment, then maybe I will do it as part of the motion, as part of my answer instead of a motion to dismiss. So there's advantages depending on the circumstances. Okay, you get that part of it? Okay? Because when we've talked about raising personal jurisdiction, it's got to be done in the first offensive move. We talked about that. So that means either a motion to dismiss or as part of your answer with an affirmative defense. Because the failure to raise it waives it, right? Same thing with venue. But subject matter jurisdiction can be raised anyone at any time. Thank you. Okay, questions? Rule 12 is really important. You're going to experience it often in practice. And you may use it in practice as well. You will use it in practice as well because it gives you, here's the other thing. It's supposed to be giving you practical tips as well. So the client comes in, you've got 3 days left to file the answer. You could get an extension if they give it to you. The first thing you got to worry about is, because before I put my name on anything, really, I got to be paid. And I'm not filing an answer subject to Rule 11 and all the rest of it before I've got money. And so one way to not have to invest all of your time and money in it, your Rule 11 investigation and your complaint and any counterclaim, is a motion to dismiss as a relatively short money thing to do while they're going out and getting the balance of the money they need to pay you in order to make this worth your while. And so sometimes we'll use the motion to dismiss just to buy us that time to factually and legally investigate the matter, to grab any supporting documentation for counterclaims, but equally as important to be able to get the fee arrangement signed and to be able to get the cash sufficient that you're going to put your name on things so that you paid for the type of work that's required in investigating factually and legally any answer and counterclaim, and then filing that at the appropriate time with the court. Because people do not come in to see you necessarily as soon as they get the summons, and that creates a real issue you have to deal with. A lot of times it's relatively easy to get a 30-day extension from the other side.
Now, where's the line drawn with, I've seen this happen where clients will come in, the lawyer says, I'll do the motion to dismiss and all that, and 2 weeks later, the client has vanished, and now you're...
Yeah, I'm not sure I would file even the motion to dismiss without payment. Because you're right, they're shopping around.
Right.
So you wanted $5,000, Chief said he'll do it for $3,000. He's not even gonna call you back.
Right.
And by the way, absent money or a signed fee arrangement, how do what evidence do I have that I represented them? That they said, oh yeah, you're my lawyer, that's why we have written fee arrangements and that's why we take money. Because people do not understand how quickly, especially in civil litigation, but the divorce litigation, you name litigation, any piece of litigation, it's very, very easy to run up a lot of hours very quickly. Very quickly. Someone's going to pay for that. Because that time, ultimately, if you're spending 10 hours on this case and you're not being paid for it, that's 10 hours you could have hopefully spent on someone else's where you would have been paid. It's money out of your pocket, your bills aren't being paid, and if you're working for yourself, that's one thing, but if you're working with partners, then they're not happy either. So you gotta think about the business aspects of your cases as well. And so we can look at the rules, and the rules do help us think a little harder about some of the things we want to do and should be doing in practice. But let's talk about Frank's GMC versus General Motors Corporation, because it's a good case, and there's a bunch of little things going on with it that I want to ask you about as we think about their request for preliminary injunction here. The first thing is this matter was entered in state court by Frank's, right? Frank's files in state court in New Jersey against General Motors Corporation. And Frank's was looking for an injunction to prevent GM from pulling its warranty business. So Frank first filed in New Jersey State Court, and then it says, following removal from state court, we're then in federal district court in New Jersey. So that's my first question. What allows you to take an action from state court to federal court like that?
Removal jurisdiction.
Removal jurisdiction. What is removal jurisdiction?
When you have a claim that could be filed in both state or federal court, you can choose
Who can choose?
the moving party.
So who's the moving party?
Plaintiff?
Nope.
The defendant.
Who got the first choice of entering the complaint? Right? The plaintiff.
Plaintiff.
So now, the plaintiff gets the first move, not the last move. Now, it's the defendant's option to remove an action from state court to federal court that could have otherwise been filed in federal court in the first instance, right? So when we say that could have otherwise been filed in federal court in the first instance, what are we talking about?
Facts have diversity.
Okay, diversity jurisdiction would be one, federal question or constitutional issue, right? If removal jurisdiction is based on a constitutional issue or a federal question, it makes no difference that the defendant might be from that forum where the case was entered in state court. If removal jurisdiction is based on diversity, the defendant cannot be from that forum. In this case, the defendant is General Motors Corporation. Where are they from? You don't know where General Motors is from? Yeah, everyone should know where General Motors is from, no?
From Michigan?
Yeah, Detroit, right?
Yeah.
Right? Detroit, overlooking Windsor, Canada as well. So, can GM remove the matter on the basis, this is no federal question, there's no constitutional issue here. The argument at best is a breach of contract claim, right? So, it would have to be based on diversity. Frank's is from New Jersey, GM's from Michigan. Do they have a claim reasonably likely to exceed $75,000 as he sees it? And the answer is yes. GM decides they would rather be in federal court. Why do you think GM wants to be in federal court? Good.
It's more advantageous to corporate.
Yeah, right. It tends to favor corporate America. The fact is, Frank entered in state court of New Jersey because he thought, as a New Jersey citizen, that the court would be more likely, a state court would be more sympathetic to him. I think he's right. And General Motors understands that well. And they said, well, you know what, that's nice, but we don't think this serves us well. We want to be in federal court. And remember, the other part of that, just as you start to think this through, is if General Motors wants to try and transfer it to some other place, like maybe Michigan where they're from, you can't transfer from a state court to the courts of a sister state. You've got to remove it first from one federal court and then seek to transfer it to another federal court. So, well, I don't know whether this is their last move, but it certainly is a good first move for them to go where they think they might have a more sympathetic audience, and where Frank certainly is likely to have a less sympathetic audience, since he's not from the county any longer where the case is filed in federal court. So what happens here is Frank's had been a General Motors truck distributor for many years. They had serviced General Motors warranty business, but then General Motors decided that they want out of the truck business, heavy-duty truck market. Obviously, it wasn't, as they saw it, in their financial interests anymore. And Frank says, whoa, wait, not so fast. I think you need to stay in this business and allow us to continue to service the warranty on it. And we want an injunction preventing General Motors from terminating the franchise and preventing us from being able to service these vehicles under the warranty program that General Motors and Frank's previously had under a cooperative relationship. But General Motors made a different deal, as it saw that would be more advantageous with it. They decided to cut a deal with Volvo and let Volvo take over the manufacturing and marketing of the trucks in North America. So it told Frank, you're out. And Frank said, well, I'm still thinking I'm getting heavy-duty trucks because I've been I have a superior record of sales with GM, but Volvo GM informed Frank, well, sorry, you're out. We don't want to use you anymore. And Frank's was told, stop taking orders because you're not getting any more trucks. And that if you, and even on the parts, we'll decide on a case-by-case basis. So you're going to be in trouble even if you say you're servicing these. Frank sought money damages for breach of contract. He also sought injunctive relief to prevent them from discontinuing its supply of heavy-duty trucks to Frank's. We already talked about they removed the action. There was an argument in the federal court. Court reviewed the submissions of the parties, denied Frank's request for an injunction, preventing GM from terminating its supply of the trucks, finding that it, finding that it had met its burden of the issue of likelihood of success. Nevertheless, the court did grant interim relief in part by ordering GM to continue supplying parts and warranty administration for heavy-duty trucks to Frank's pending the outcome of the litigation. So Frank's isn't going to get trucks, but he still can, at least as the court saw it, get parts and participate in the warranty program. And it's odd if you look at the language here. It says the district court, observing that it was unclear as to what irreparable injury, if any, Frank's would suffer from General Motors' refusal to continue to supply its parts, but thought that the balance of harms tipped so much in Frank's favor that they decided to order it anyway, even though, in essence, what Frank's has here is, I think, at likelihood at best, is a claim for money damage. Right? He's got an adequate remedy at law. He has trouble satisfying the irreparable injury part of the 5-part test. But at the end of the day, the court is sympathetic to Frank and decides to issue it anyway. And so when we look at Roman numeral 2, it says, when we're looking at determining whether an injunction was appropriate or not, the standard for review is, has there been an abuse of discretion, right? We've talked about this many times. Request for injunctive relief rests with the sound discretion of the court as long as the 5-part test is honored. And deciding whether there's an abuse of discretion means we're going to have to show there's an error of law or a clear mistake in undertaking the requisite analysis. And so the problem here is the injunction actually requires GM to continue to participate in a warranty program with Frank's that it no longer wants to do for business reasons. It has delegated this to another company. It's created a joint venture with them. And the expense of this injunction will be significant to GM as they see it. You know, at the time, one would argue, well, GM's got plenty of money, what's the big deal? But the fact is that GM is saying the harm that tips here is heavily weighted to us, not Frank's. If Frank can establish that there is some breach of contract and he's got money damages, well, let him prove it and we can pay it. But he's not being irreparably injured. And the court goes into this whole discussion about injunctive relief is an extraordinary remedy. The court has to look at whether the preliminary injunction was appropriately granted based on the analysis of the 5-part test. Here, the court is really struggling and greatly concerned that how do you get past no adequate remedy in law when Franks is really arguing, I'm going to lose a ton of money here. Well, that's a money damage claim. That's not an injunctive relief claim. How do you get past that he has not shown an immediate, irreparable injury, right? The argument being is that that it's not irreparable, we can fix this, and we can fix it with money. And then the third part of the test here, with respect to the balance of harms, or the fourth part, the court, in looking at it, says, you know, General Motors is going to be significantly injured, harmed here, if they're required to participate in this program. The financial harm to GM is significant. So the analysis the court looks at here, it says, in Morton, we noted that a purely economic injury, compensable in money, can't satisfy the irreparable injury requirement. If you think about that, as this court does in this case, if you can show that this at its core is really only a purely money damage claim, then you have trouble satisfying both the no adequate remedy at law standard as well as the immediate irreparable injury. Because at the core, this court, the appellate court, sees this as a money damage claim. And under those circumstances, regardless of how sympathetic they may be to Frank, this is not an appropriate case where the sympathy should overrule the law here. And the fact is that this is not, as this court sees it, a not appropriate use of a preliminary injunction, regardless of how sympathetic it is. Now, I want to think about the second half of this, about the bond, because we're going to start to look at the bond stuff a lot more closely when we think about the procedural requirements of whether the injunction is granted and what happens if it is, what are the procedural prerequisites to granting that injunctive relief. And so the problem here is that General Motors is saying, well, listen, if you're going to issue this injunction, as the district court did, we need a huge bond. This is going to be a very expensive program that you're asking us to continue to undertake because we're out of this business. So we're going to have to hire people, we're going to have to continue to make parts, we're going to have to ship them, we're going to have someone to process all this warranty work of Frank. This is not insignificant amounts of money to General Motors. The requirement of the bond on an injunction is to provide for damages in the event it's later determined that the injunction is wrongfully granted. So this bond argument and the bond factors become another argument against granting the injunction. If I can ask for a high enough bond and get the court to agree that that should be posted, if the moving party can't post that bond, then the injunction doesn't issue. So you need to start to think about the whole bond argument as another argument used to help defeat obtaining the injunctive relief. And start to think about it in that balance of harms. When we want to talk about the five-part standard and we want to talk about what the harm will be to you or your client if that injunction is granted, you now have to think from a less abstract point of view about that and try to monetize it. When we're saying what's the harm, what does that mean in dollars and cents, what the harm to your client will be? The greater that you can establish the monetary damages of that harm, that should be, hopefully, the amount that the bond that the party seeking the injunction has to post. There will be times where you can make that amount so significant that the person won't be able to obtain, the entity won't be able to obtain the bond. It's not financially feasible to post a bond of that size. And in this case, General Motors could put forward a significant argument about the bond. Look at footnote 7. It says, the record reflects that if Franks does not prevail, GM will have been damaged by any difference in the amount it will receive from Franks as payment for the parts it must provide to Franks and the amount it pays to obtain the parts, by the amount it will expend to set up and administer a warranty service program, as well as the claims it will have to pay Franks GMC for doing the work, because Volvo GM agreed to assume responsibility for all warranties. Franks argues that any damages incurred by GM are its own making because GM has made the choice to dismantle its warranty program. But GM can decide to do what it wants to do for its business. Either way, GM would have an expense of this program, whether they were doing itself or having passed it off. In this court, as they're looking at the bonds, they're saying under our law, under this is the Third Circuit here, that there must be a bond posted, because as they interpret Rule 65, and we're going to see a little variation here, and that's why I want to point it out to you, they interpret Rule 65, which is in the manner in what it says, that a court must require the successful applicant to post adequate security. That's the bond. Although the amount of the bond is left to the discretion of the court, the posting requirement is much less discretionary. While there are circumstances where the requirement of the bond may be waived, but those circumstances are so rare. The only time they say here is when there is no risk of any monetary loss to the defendant. The district court's failure to require the bond to be posted under those circumstances, it's not reversible error. But what this means is you've got to be prepared to make that argument and to put dollars and cents attached to that argument, because otherwise they need to post the bond. And that's what the argument here is. GM was making the argument, then there needs to be a significant bond. Court didn't make Franks post a bond at all. Another reason to reverse the grant of the injunctive relief here.
I don't know if I got it right. Did you say the district courts may request a bond? Is there a scenario when?
No, the rule says, and this circuit is interpreting as the district court must, if they're going to grant injunctive relief, must require that the moving party post the bond.
Okay.
But must require that the bond be posted, but the amount is more within the discretion of the court. And we're going to see that creates other problems. But while it's discretionary, let's remember what it's for. It's for any damages the non-moving party would suffer in the event the injunction is later determined to be improvidently granted. What that means is you've got to put forward a strong argument as to what the basis for those damages are. Because then it's not so discretionary when GM says, listen, this is a couple $100,000 program you're asking us to be able to continue to have to put up every year. And so that means this bond should be of at least $200,000. That's not going to be an easy bond to obtain. But so you've got to put the argument up as to what the bond should be here. And here, the court's failure to require any bond, the court sees as another flaw with the court's granting injunctive relief, especially in view of the earlier consideration about how weak, or how, not even just weak, but how they were unable to establish likely 2 of the 5-part test. And in this case, as they go on to say, that they recognize that GM would suffer harm and losses here, but nonetheless still didn't issue any injunctive relief. So what they do is they vacate the injunction because they do find that the court improvidently granted the preliminary injunction, and they find on the basis that because they didn't post the bond. And so they sent it back to vacate the preliminary injunction. This bond becomes pretty important, as we're going to see. What we're going to find, though, is there's a lot of latitude depending on where we go and what circuit we're in with respect to the court's flexibility on that bond. Let's talk about Sam Ayoud versus Mobil Oil Corporation, because this is always one of my favorite cases. And one year we did this case here, and one of our students, this was his uncle. Not so sure I would have shared that with everyone after reading the case, but he did. He was a good guy, but his uncle, not so much. But let's talk about this because it's an interesting case, and I'm wondering how, one thing principally is how you would avoid problems of this nature. So this was a matter before Judge Nelson, cross motions for PI, and again, we've talked about this a couple times, but we always tend to think that it's the plaintiff seeking injunctive relief, and it almost always is, but that doesn't mean the defendant can't seek injunctive relief, but in order to do so has to file a counterclaim, because you have to have a legal injury to seek injunctive relief. So as long as you do, then that creates a situation like this where not only is the plaintiff moving for a preliminary injunction, but so is the defendant. Which, by the way, sometimes the plaintiff will sue solely for money damages. That doesn't prevent the defendant from bringing a cross-claim and seeking a multiple count complaint for money as well as injunctive relief. So sometimes it's only the defendant. That's a little rarer. But here what we've got are cross motions for PI, and we've got a Court of Appeal decision before Judge Selya, who, lucky for you at this point, I think he's not just senior status but retired, because when you had to read Judge Selya's decisions, you had to have a little dictionary sitting next to you, as you should have found when you looked at this case. But at any rate, you know, another thing, I'm going to use it to mention it, because when I was admitted, I had a really good civil procedure teacher, but when I was admitted, she never said much about this. The federal court, in addition to having rules like this, has what we call local rules of court. Every federal court has their own local rules of court, okay? And there are specific, more detailed things that you have to do in filing certain motions and the like with the federal court, and they're governed oftentimes by the local rules. They may be the size of the brief, they may be the size of the font for the brief, for the pages in the brief. In this case, the reason I'm bringing it up here is originally that when you filed your paper briefs with the court, you also had to file a copy of the brief on CD or DVD at the time, because Judge Selya was losing his eyesight and needed it on an electronic image so that he could enlarge the print. Now, all your briefs, everything virtually, is filed in federal court online. It's relatively simple, but so my point is that sometimes the local rules will dictate how specific motions and the procedure on specifically before that court has to be done. And if you don't comply, not just with these rules, the federal rules of civil procedure, but the local rules within that jurisdiction, your motions will be denied, or they'll be just returned to you immediately. And you'll, so my point is, always check to see what the local rules require. One thing we do have in our circuit, the First Circuit here, under the local rules, is any discovery motion you file seeking to compel production, you have got to put within that motion certification as to that when you discussed it, who was present with discussing the issue, what you were able to resolve, what was left undone, and how long it took, and this or that. The court wants to know, by way of written attachment with your motion, that you actually tried in good faith to work out the issue before you brought it to the court. And that's one of the local rules. And that one is more often adopted now. You see sometimes some states have that same rule, and many other circuits have rules similar to that. They don't want you just dumping discovery disputes on them. Again, the point of this is you guys need to look at the local rules to make sure you're in compliance with them. Because they treat a whole bunch of different things. Oftentimes they're not, you know, there may only be 15 pages of them in their entirety, but they're important to make sure you comply with. At any rate, so now we're in the First Circuit, where many of us will in fact practice, and so it's obviously particularly important to pay attention to the process here, because we are seeing variations even among courts that are geographically close, between the First and Second and Third Circuit already. So at any rate, what happened here is this is a fight between Mobile and Sam. And so he wants to operate 2 stations. Mobile has a rule, it's within its power to do so that says, no, we want each of our store owner operators to operate a single store and devote all their attention to that and no others. And so he decides, though, that nonetheless, he was going to operate a second one, and decided to do so. He made arrangements with a Mr. Monahan, who had a mobile station in Shrewsbury. They both were in Shrewsbury. When Monahan decided to leave, plaintiff decided this was a good business opportunity for him, and he decided to, despite knowing that this could be problematic with mobile, decided to move forward and seek, he bought it or was buying it from Monahan, sought approval from mobile for doing so, and moved forward with purchasing this second station, and this is where the problems came up. So what happens is AU took possession of the station, didn't tell anyone, and you can read Celia's language here, which he likes to be clever. And so there was an agreement. He took possession of the station before he had written approval. He took title in all the property from Monahan, paid the full amount, and between Monahan and AUD, it didn't require any written approval from mobile, but AUD knew all along that this was problematic, that mobile still had, at the end of the day, the ability to approve it. Before too long, it became clear that AUD was operating the station, but what he was doing was continuing to have all transactions with mobile continue in Monahan's name and dealer number, and have all the payments to mobile funneled through Monahan's checking account. Not quite appropriate as mobile saw it, and since he was doing it in the dark, it would seem like he might well have known that there were problems with it as well. He says that mobile had approved the transfer, and he went forward with this based on those assurances. Mobile says that's not what happened. He sues for his preliminary injunction to keep where he is, and he admits at one point that the district manager said that mobile wouldn't give its assent. But he still didn't let up, and as you can read how AUD was still aggressively pursuing it, decided to file suit, and obviously the court doesn't care much for him as the plaintiff here. It says, plaintiff was not about to let his prey slip through the contractual crack. Monahan repeatedly offered to return the money, rescind the transaction. AUD kept control of the station. Monahan fronted by holding himself out as the dealer. So, lots of problems here. Plaintiff, in late '87, plaintiff sues mobile, attaching to the complaint what purported to be a copy of the AUD Monahan purchase agreement. After discovery proved that the agreement was a fake, mobile notified Monahan that because of his complicity in the fraud, it was now terminating the franchise. AUD responded by filing a second action. So we got a couple complaints. Now listen, I want to focus on this, that after discovery proved that the agreement was a fake. Note 2, it says, in his discussion with Schultz, plaintiff inflated the price paid Monahan, presumably to give him better leverage in dealing with mobile. The next day, at AUD's instigation, he and Monahan prepared another agreement inserting a price of $175, which was double virtually the $90,000 he paid. They then backdated it, signed it, and now admits that the document was bogus. But here's my problem. You as his lawyer, attach that to the complaint. I assume you thought it was legitimate, because we wouldn't participate in something fraudulent like this. Well, how do we prevent ourselves? Because you don't look good here either, right? You're representing a scummy guy who now in discovery has been caught cheating and forging documents. And by the way, once you read footnote 2, we don't have to read the rest of this case to know how this ends, do we? He's not getting his PI, Mobile's gonna get it, and he's gonna get kicked out. He's lucky if he doesn't get sanctioned significantly. But here's my question. How do we prevent against getting used like this? Right? I mean, we've got a client who gave us a document, looks legit. I would assume that we as the lawyer weren't willing participants in the fraud, but by filing the complaint like this, we're done once that complaint is filed. I mean, we're not done, but once that fraud is discovered, we're done. And that's gonna happen if the other side dots their I's and crosses their T's. And I don't know what he was thinking, that Mobile Oil was gonna represent themselves to find some schmo in the street. They weren't, you know. Who did they? Mintz Levin, for crying out loud. They're one of the biggest law firms in Boston. You really thought you were gonna pull one over on Mobile? I mean, but that's my point. How do we avoid getting caught up with someone like this who, I mean, looks like he is a legitimate businessman, has lots of money, runs a couple mobile stations, but he's a cheat and a fraud, and I assume you didn't know. I mean, if you got involved knowing it, and now your reputation is tarnished as a result of your willing participant in the fraud, well, you get what you deserve. What I'm wondering is, how do we flush something like this out so that we don't get sucked in and have someone think our reputation is poor because of the company we keep? Like, how would you uncover this before filing suit?
Due diligence?
But like what? I know that's okay, that's great language, due diligence. This is where the rubber hits the road now. Okay, you know the language. What do we do? They give us stuff that...
Background checks.
Background check how, though? I hear you, but we have to be that distrusting of a client? Here's what looks like a legitimate businessman, no? But this is deadly to his case. And listen, a lot of times I will absolutely attach what I think is strong evidence that supports our case. The P&S, sure, I would think if that's legit, it makes us more sympathetic. We already paid $175,000. We operate one good station, why can't we operate another? I got strong evidence, I'll attach it. But now, in attaching it, this case is over once you read that footnote. Once he and you are helping him perpetrate a fraud upon the court, this case is over. But you want to go back to that court someday, don't you?
My inclination would tell me, and I don't know, I'll probably run into another ethical issue with that. There has to be some type of business records out there, some one-stop shop to, figure out who is the franchisee, or the agreements out there.
Well, he's given you the agreement. Should you have talked to Monahan?
That's what I'm saying. You run into another ethical problem there when, your client is this guy and you're about to go over here and pretty much confirm what he's telling you with your non-client. Not even potential client.
You don't trust me?
Right. So.
But okay, and I hear you, but so is that, am I overly cynical from practicing law for that long, 35 years? Because I read this case and think this could happen to any of us.
Right.
And that's not the way you want to start out practicing law. So, I guess, how do you flesh out the phonies? How do you flesh out the frauds? Because this is terrible. And look at the language the court's using. This court is not accepting this lightly. Fraud, complicity in the fraud. And now you're seeking in these interim injunctions, arguing about immediate irreparable harm. And that's the other thing, right? So the speed of which this is all ratcheted up. He's coming in screaming at you, we got to do something right away. And this is one of these where maybe you didn't dot your I's and cross your T's, because he's got this emergency mobile, this big 800-pound gorilla is coming. And no one, I mean, God knows what we were paying for gas back then, but no one cares about poor gas companies. They're not poor gas companies, they're making a fortune. But he's got you knee deep in his own fraud, and it looks horrible. And so I guess I'm wondering, what I'm cautioning you about is, and I've done it a couple times, and I gotta keep saying it, especially when you're not following, the standard protocol, or you're gonna try and cut down the timelines on some of this, because PIs, that's the nature of, the urgency of the situation. You gotta take a step back and make sure that you're not gonna run afoul of Rule 11. That's the problem with this, is I'm sure whoever did file it did so with some sense of urgency, because the client is saying that mobile's going to come in, they're going to stop my gas, they're going to terminate the service station, and if we don't have mobile, we don't have gas, we don't make money. So it's got to be done right away. He gives you what appears to be a P&S that looks legit, signed by the players. They're playing you, or they're playing each other, or they thought they're playing mobile, but you're knee deep in all of this. And like I said, maybe he didn't know, but you should have known. These big corporations, they don't roll over and play dead for anyone. Oftentimes, they're the king of the scorched earth defenses, because they figure if they're an easy target one time, the word gets around, it's cheaper to defend your case to the death than to pay you a dime. I'm going to stop here, but I want you to think about, okay, I know the language, I know what Rule 11 says, but how practically do we avoid problems like this, where they give us stuff that later turns out not to be legit, and that's a problem. And how do we then not become complicit in it? I had this invention dispute one time. Ultimately, I had the good guy, just to be clear. But ultimately, it became clear, and I was able to prove it through discovery, that the co-inventor had absolutely fabricated stuff in the invention book. He had put stuff in there, the dates, as it turned out, we could prove he wasn't where he said he was when what's in there. He went back and fabricated evidence, and I told the lawyer, I said, that's fabricated at this point. So, and to me, I think he did know. He had to know. It was clear to me. It was clear to anyone else who would look at it. So now you're attached to that fraud. And to the extent you continue to push and advance that defense, aren't you part of that fraud? And that's the way I saw it. And I still think I believe it's right. Because at some point you know it's wrong. And to the extent you're continuing to be involved with it, you're just as complicit as the court says is Monahan. I'll let you go. We'll talk about it next time, because there's a lot more in here about enjoining trespasses, and that's something else we'll talk about. There's a hearing. And there's all sorts of problems procedurally with this case, so I want you to look at it. But you know what? The court doesn't care, because they don't care about this fraud, this trickster, this person that tried to perpetrate a fraud upon the court. All of the mistakes are going to be excused, and there are a ton of them. So it's important to look at it here. But what's most important to remember is if you don't have a sympathetic client, this whole case, you are not getting the court to do anything for you, even where there's been significant errors in their work.
What's interesting is that as a lawyer, you would see Mobile Oil Corporation, you would know it's a franchise. And your first inclination would tell you that the P&S would have some type of mobile signature.
You would think that somewhere in there, mobile should have been signing something. And he should have had the franchise agreement that talks about the transfer. So we'll talk next time. We'll finish up.